All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in Cammock against Foothills North Owners Association. Our cause number 1CA is CV21-0165. Counsel, you'll notice that we have socially distanced the courtroom and you each have podiums from which to argue, so mask usage is within your discretion. Each side has 20 minutes for oral argument, and the appellant is responsible for monitoring your own clock to reserve any time you wish for rebuttal. And with that, we may begin.
Thank you, Your Honor. May it please the Court. My name is Whitney Cunningham. I'm with the law firm of Aspey, Watkins, and Diesel. With me here in the courtroom today, as well as on the briefs, is Michael Victor. We are here on behalf of Bill Cammock and Susan Cammock. We brought this appeal because of post-judgment activity that resulted in financial damage as well as ambiguity in this litigation. In January of this year, the court entered a judgment under Rule 54C certification granting our request for injunctive relief and ordering an award in our favor of attorney's fees. But subsequently, upon motion of the appellee, opened the issue of whether Timmy McDonald was entitled to an award of attorney's fees, ended up granting that request, and in our opinion, calling into question, in part, the validity or at least the scope of the injunction that had been entered in January.
It's really a question of, if I'm understanding this right, you're worried that your injunction isn't fully enforceable because of community property issues?
Judge Swan, we would expect that our injunction to be fully enforceable, and it was entered against property which is co-owned by Mrs. McDonald. But Mrs. McDonald asserts the position that she was dismissed from the case in September of last year and persuaded the judge to enter an award of attorney's fees for that.
If the attorney's fees hadn't been awarded, would you be here?
No.
Because you're essentially the prevailing party, but are you concerned that the dismissal somehow undermines the enforceability of the judgment you got?
Yes. So the answer to your question is no, we would not be here, but for that award of attorney's fees. The January judgment on all fours was in favor of our clients. Only subsequent to that judgment was this issue sort of unpacked and opened up about whether Ms. McDonald was entitled to an award of attorney's fees, and being awarded those fees, we deemed that it was important for us to bring this appeal.
Okay.
Now, the genesis of the issue before you is simply whether or not we fairly pled a claim for breach of contract. And Timmy McDonald is a co-owner of the property. These are two neighbors, live next to each other in the Foothills North subdivision in Sedona. Mr. Schwartz and Mrs. McDonald, who are a couple, filed or made an application to enlarge their driveway coming within just a few feet of our client's property, which on its face would be a violation of a setback within the CC&Rs. Upon examination, we argued that the application for that enlargement was deficient, that it did not meet the terms of the CC&Rs, and also that it was inappropriately approved by the association. We brought a one-count complaint for breach of contract against the owners of the property, both of them, and the association, alleging violations of the CC&Rs. That's where this case stops as it concerns Mrs. McDonald. She brought a motion to dismiss, arguing that we had not fairly pled a claim of breach of contract against her, and the judge, a different judge at that time in the case, granted that motion. The case then proceeded against the husband and the association and resulted in the January judgment that I was talking about before. I think on our briefs we fairly explain why CC&Rs are, in the state of Arizona, considered a contract. They are a contract between and among the owners of a subdivision. Owners take property subject to those CC&Rs. The Continental Oil versus Fenimore case is probably the classic case, 1931, that sets forth these principles, as well as the remedy, which is to seek injunctive relief in order to enforce them. We alleged specifically that both husband and wife violated the CC&Rs in the scope of the application that they submitted, as well as the undertaking of improvements in violation of the CC&Rs. In response, what you primarily heard in the answering brief was an argument that Mrs. McDonald had a right to rely on the decision of the association. And I think I would simply point out that that might have been a legally and factually interesting defense for Mrs. McDonald to have raised in the face of our legally sufficient claim for breach of contract. But that's what we were denied the opportunity to litigate, at least as it concerns her. Again, if this case had ended with the January judgment, I don't think we'd be before you.
Schwartzman and McDonald are married, no?
Yes.
Okay.
Yeah.
So I'm. Is it just belt and suspenders that you're arguing the sufficiency of a contract claim against her? Your argument could start and stop with community property, right? Possibly,
but so a couple of answers to that question, Your Honor. First of all, we affirmatively alleged that Timmy McDonald was an actor here and that through her acts and omissions, the CC&Rs were violated. In addition to that, I think it's paragraph 22 of the CC&R, or of our complaint, we point out that the CC&Rs make co-owners of property in the Foothills North subdivision jointly and severally liable for the actions of each other. So that would be a separate basis.
Sure, and in Missouri, that would be a really important argument to make. I'm not sure it's even necessary in Arizona.
It may not be necessary, Judge, but the fact of the matter is we made both of those arguments and we made them in a legally sufficient way. And therefore, we believe that we were entitled to proceed with our claim against Mrs. McDonald.
Okay.
All right. Unless the court has other questions for me, I believe that fairly presents our case.
Thank you.
Thank you, Your Honor. Christopher Goodman for Timmy Diane McDonald. She is not here today, but she's watching on the live stream. May it please the court, I want to start with that apparently this case arose, and this is what I'm hearing for the first time, that this arose from a post-judgment activity after Ms. McDonald was dismissed from the matter. Ms. McDonald was dismissed from the matter in September of last year, and the judgment activity they refer to apparently occurred in January, February, and March. And I think the court certainly identified the issue here, and the issue is the award of attorney's fees. Ms. McDonald was dismissed. There is not a question of whether she was or was not dismissed. There is not a question.
The question is whether she should have been dismissed.
The question is whether she should have been dismissed, and if you want to jump to that, we can. In the complaint, and the opening brief certainly distilled exactly what allegations the appellants contend were against Ms. McDonald specifically. The only contractual obligation that is identified is apparently the sufficiency of a submission to the architectural committee.
Well, but again, we're not in Missouri. Why does there need to be a specific allegation against Ms. McDonald? This is a community property state. We have laws and court rules requiring that spouses be named jointly. Why isn't that the end of the inquiry?
Because she didn't breach the contract.
That evades my question. If this were a tort case, she may not have been driving the car. She may not have been anywhere near the car, but she'd still be sued.
Well, in the same complaint that they submitted was sufficient, they say that and they cite to the CC&Rs that say that the joint owners of property are jointly and separately liable for the acts of one owner. Therefore.
But we have pleading rules and community property statutes that require both spouses be named. Right?
Ms. McDonald is entitled to a defense to being accused of breaching a contract.
Sure, she's entitled to a defense, but that defense relates to the merits of the underlying allegations against the community, not to her individually.
Well, the allegations against the community continued into trial and ultimately were found.
Yes, but except the community was no longer party to the case because she was dismissed.
Well,
and it seems to me that this is sort of bar exam material. One would be faulted. It would be malpractice not to name Ms. McDonald in this case. So I'm struggling to see how she gets dismissed. It might be that she has a very valid defense to allegations made against her, and that could affect the contours of the result of the case. But how she gets dismissed is beyond me, because it seems that she has to stay in as long as the claim is alive against a member of the community.
Well, Your Honor, but all I can say to that is that she's entitled to a defense. They named both. They did not allege specific conduct by Timmy.
Okay, so if this were an auto accident case, husband's driving the car, wife is in Europe at the time, has nothing to do with the accident, but still gets sued, would you be making this argument?
No.
Wife is in the case at that point, right?
Yes.
Why is this any different? Isn't this an a fortiori case?
Well, it's a proceeding against the property. It certainly is a proceeding. Really what they should have done is sue the HOA and leave Schwartz and McDonald out of it to begin with.
Perhaps so, but I don't see the basis for treating husband and wife differently here.
Okay. The basis is there were specific allegations against Mr. Schwartz that he had induced the HOA to give their approval to the project. There were specific allegations that Mr. Schwartz...
But wasn't all of that at the benefit of the community? All of his actions were for benefit of the community.
Yes.
Well, then why isn't she in the case? It makes no sense not to name her in the case.
Well...
As it turns out, there's an award of attorney's fees, and didn't that award of attorney's fees go against the community as well on the injunction?
It went against the Cammocks as a community. Yes, and the award of attorney's fees went against the community of Steve Schwartz and Timmy McDonald. When the Cammocks...
Well, how can it go against her because she was dismissed out?
Well, I mean, it was... That's a good question.
I try now and again.
Yes.
I think Judge McMurdy may have hit the very essence of this appeal. There can't be a judgment against her if she's dismissed, but the judgment, whether you agree that the judgment should have been entered at all is another question, but if it's going to be entered, it should have been entered against the community, which is the very reason we have rules requiring joinder.
The judgment was entered against the HOA, and the approval of the plans were revoked. Okay.
I'm sorry, I couldn't hear that last sentence.
The judgment was entered against the HOA as well as Mr. Schwartz, and the approval of the plans were revoked. There was not a situation where Ms. McDonald claimed some separate right to continue to construct on the property separate of Mr. Schwartz because the judgment was against Mr. Schwartz or an injunction against Mr. Schwartz. So practically there was not that situation. Practically there wasn't the situation.
But she also made a claim for attorney's fees.
Right, which were...
And those attorney's fees would have been on behalf of the community, which would have included her husband, which he went on and lost. So I'm really confused how she could make a claim for attorney's fees on behalf of the community and then turn around and say, oh, but I was properly dismissed. I mean, I'm with Judge Swan. This seems like first-year law student material, actually.
I think that's the second time I've heard that today.
Well, I at least took it to the bar exam.
Yeah, thank you. She did not make the claim for attorney's fees on behalf of the community. She made it separately. She made it as Timmy McDonald. And the invitation to submit an application for attorney's fees was made.
So the award of attorney's fees if paid, isn't it not a community asset at that point in time?
Well, I guess we get a factual issue as to...
No, it's monies that have come during the court. They're not divorced, right?
No.
Okay.
So it's monies that they've accumulated during the course of marriage. Those are by definition community monies.
Well, I don't know if she paid, and I have to admit, I wasn't trial counsel. I don't know if she paid the fees with her separate funds or joint.
The positions you're asserting are absolutely logical and reasonable and would even comport with the law in a majority of American jurisdictions. But we're here in Arizona, which is a community property state. Can you help us get past that?
I can try.
I'm sorry?
I can try to get past that.
Okay.
And here's how I'm going to do it. The claim really here is against the property. It is against the HOA, and it is an injunction against the property and to stop construction on the property. And so
Can you have an in rem injunction?
No, you can have an injunction with the HOA, which frankly is who should have been a defendant here. The HOA approved the plans. They should not, apparently, under their argument, and frankly what the court ultimately ruled in December, the HOA should not have given the approval.
Well, again, you may be 100% right about that. That's not really before us. But it would, again, probably be malpractice not to join the property owners, because if you get a successful result against the HOA, property owners aren't parties to that judgment. They can just go ahead and build, and then you've got to sue them to enforce the logical consequences of the judgment against the HOA.
Well,
so including them all does make a certain amount of sense, doesn't it?
Well, it makes sense if they had simply wildcatted and decided to go ahead and build this driveway without getting any HOA approval. I think here the HOA is the party that they have a claim against, which is a claim that they didn't follow their own procedures in approving the driveway. Now, I have to admit, I don't understand. I think the distinction between Timmy and Mr. Schwartz was drawn because there were specific allegations of Mr. Schwartz that he, induced the HOA to give approval, or he somehow coerced them, or somehow coordinated with them to get approval. But otherwise, I think he would have been let out. And ultimately, the injunction was against the defendants, but the injunction was against the HOA, saying, HOA, follow your own procedures and, approve this driveway, which, incidentally was approved.
And defendants don't go ahead and build something that the HOA hasn't approved properly.
Right.
Yeah.
Right. And so that's when you might name the individual homeowner or the neighbor. But if the HOA has approved something that you feel that they have not followed their procedures, then you can sue the HOA. You win against the HOA withdraws their approval. If the homeowners continue to build, then at that point, I suppose
you have another lawsuit. And at that point, do you get to sue both? What if in that case, wife has nothing to do with building, frankly doesn't even want a driveway, but husband wants the driveway of his dreams and he's building. Now do we have a different case, or do we have to sue them both?
I don't think you have to sue them both at the beginning. I think the remedy here was against the HOA and not against McDonald and Schwartz.
Well, okay, but I'm playing out your hypothetical. So you get the injunction against the HOA, and husband decides to build.
Okay.
Is there a case against wife at that point?
No. I think
wife owns the property. It's going to be her driveway too.
Well, there's a term in the CC&Rs and the very contract they rely upon that makes all owners subject to the acts of one owner.
That fact would seem to go against your position in this case.
I think that fact actually allows them to sue one and not the other. They can still bind the property with an injunction even if they haven't named all the owners.
But there's nothing in that undermines the applicability of the statutes or rules governing pleadings against married couples.
Understood.
So what are we to do with that? Are we to declare an exception here?
Yes.
Why?
To declare an exception.
I mean, there are a lot of statutes that would be fun to declare an exception to, but our role is to follow what the legislature prescribes, and that's what we do.
I understand. I'd have to refer to the complaint to see if there even was a community allegation. I will note in the opening brief, all of the entire argument went to that she was bound by the contract and that she breached it. There was not an argument made in the opening brief, and if I recall correctly, in the briefings below on the motion to dismiss regarding community property. So I'm not sure if it was preserved for appeal.
But we're reviewing this de novo,
Understood.
correct?
That's correct.
And so we're applying the law as it exists. And if we apply that law as it exists, wouldn't the plaintiffs had to have noticed her?
Had to have noticed her, I'm sorry, or sued her.
Sued her. Put her in the suit because of community property.
I don't think they needed to.
Okay.
Okay.
I will defer to the rebuttal. Thank you.
Thank you. Anything, Mr. Cunningham?
Thank you, Your Honor. I would simply point out that if Mr. Schwartz and Mrs. McDonald were not married and there were no marital community, then separate and in addition to the discussion that we've already had, I simply wanted to point out, and this is in Section 2 of our Statement of Facts, there are 6 factual allegations, paragraph by paragraph, that separately allege Mrs. McDonald was herself bound to a contract, that she committed acts and omissions that resulted in damage. And that is a distinct and separate basis for her liability apart from the community, but that is also part of our brief. And unless the court has questions for me, I'll be done.
All right, thank you. Thank you, counsel, for your arguments. The case is now under advisement. We will issue a decision in due course, and the court stands adjourned.